Assistant Public Defender Hannah Apple appearing on behalf of Ms. Johnson. Ms. Johnson, can you state your name for the record?
Valerie Johnson.
Your Honor, I have an application pending to schedule a meeting with Ms. Johnson, so I'd ask for an adjournment for that purpose.
That objection, how much time? You have the application.
The application is pending, but I already have, I guess, my video visits approved. So once it shouldn't be very long, I don't expect. That makes sense.
Okay. I believe that. All right. Probable cause conference will be here on September 4th.
Thank you.
2025, 9 a.m. Bond will continue. Thank you, Ms. Johnson.
Thank you.
No, go ahead. I'll wait. You got everybody? Court does call the case of the people versus Michelle Lovaz.
John Shea, Your Honor, with and on behalf of Ms. Labaz, who's approaching.
Morning, what's your name?
State your name for the record.
Michelle Lavaz.
Thank you. All right, what are you doing?
Your Honor, the defense has been awaiting supplemental medical records for quite some time. That medical records take a long time to obtain. My understanding is the prosecutor's office has them. They will be tendering them to us. We will be tendering them to others who need to review them. I'm going to be out of the country between August 31st and September 19th, so we're requesting a PCC until after that.
Since September 19th.
Yes, sir.
You come back. I can do September 25th or October 2nd.
Your Honor, September the 25th will work just fine. At the 22nd, excuse me 1 second, Your Honor. Your Honor, it's September 25th for the time being. We may have a conflict with that, but if we do, we'll contact the court. I know I have a conflict on the 2nd.
Hearing no objection, probable cause conference, September 25th, 2025, 9 a.m. Bond continue.
Thank you very much.
Thank you, Your Honor.
Court calls case People versus Samuel Klosky.
And then on behalf of the people, Your Honor.
I realize, Ms. Cannon, you are trying to stand in my eyesight, so I know that you're actually here and we're waiting on somebody else. No, never mind. You don't have to say anything. I'm just saying, I get why you're there.
My apologies, Judge.
Your name, sir?
What's your name? Samuel Klosky.
Thank you.
Your Honor, we are asking that this matter be set for preliminary exam.
All discovery complete?
To my knowledge, yes.
People have their witnesses available the 2nd.
We'll do our best, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Freshour.
Thank you, Judge. Thanks, Your Honor. All right.
Bond continued. Court calls case People versus Eric Lightheart.
Good morning, Your Honor. Christopher Shemke appearing on behalf of my client who approaches.
Your name, sir?
Eric Lightheart.
Thank you. You're seeking an adjournment?
Yes, Your Honor. I'll have that go on.
That objection, probable cause conference will be adjourned to September 2nd, or September 4th, excuse me.
Your Honor, if possible, I was respectfully requesting consideration for the 18th of September. I fully expect the matter to find a resolution. I do not see this matter being set for an exam.
5 weeks out.
But I wouldn't be seeking any additional adjournments.
Any objection from the people?
No, Your Honor.
September 18th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you.
Court calls case People versus Kyle Beckerman.
Good
morning, please, Honorable Court, David Burgess on behalf of Mr. Beckman. We got our discoveries complete. We're requesting exam on this matter.
Your name, sir?
Kyle Beckerman.
People have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Perry. Bond will continue. Court calls the case of the people versus Latanya Marie. Oh, I'm sorry. Yeah, Latanya Marie Lee. Let's see if I get that wrong. Naya Lee. They have it. They have those.
Andrew Childers appearing on behalf of the people. Good morning, Your Honor. Sam Bernstein with on behalf of Ms. Lee. Ms. Lee, could you please state your name?
Naya Lee.
Your Honor, we're asking for an adjournment. There's some discovery that still needs to be produced, and we're working on a resolution. So a lengthier adjournment would be appreciated, Your Honor. Respectfully requested.
The 4th.
Like a 30-ish.
Pardon?
You said to the 4th, Your Honor? Could be a little
If
bit
I'm giving suggestions. Go ahead.
like the 18th, Your Honor, please.
18th. Why? This is 5 weeks out.
This is the judge zooming out and basically saying stop treating court dates like suggestions. Judges hate long adjournments when the charge doesn't justify it or when it looks like delay for delay's sake. That little lecture, that's courtroom discipline.
The other one was a retail fraud. I don't even understand why we sent that out 5 weeks. And this is
Yeah, I guess that is a little bit lengthy. September 11th, Your Honor.
September 11th, 2025, 9 a.m. Bond continued.
Okay.
Court calls the case of the people versus Christopher Decker.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Decker, who approaches. Please state your name.
Christopher Decker.
A forensic exam here is about competency, not guilt. The court is asking, does this person understand what's happening and can they assist in their defense? If not, the case pauses because you can't ethically run a trial if the defendant can't participate.
All right, you're requesting a forensic exam.
Yes, Your Honor. I met with Mr. Decker. There were some concerns raised during our meeting Saturday, so we're requesting a forensic exam. I've received the paper discovery from the people. The prosecutor also has provided me the email address, and I already sent over a request while waiting to be called for the digital discovery. I think the only holdup is how long it'd take to get the forensic center to see my client.
Forensic examination evaluation is ordered. I'll set a competency here, give me 90. We'll move it up. Yes, sir. November 13th, 2025, 9 a.m.
And Your Honor, my understanding is I don't believe bond's been addressed in this, and we just asked the court to reserve that. There's a revoked bond from a case that's already been bound over to circuit court. So I don't believe any of this time is counting on this case, but we just didn't want the court to deny bond or take any further action until we get a response back.
He's got a 25,000 cash shirt.
On this case, thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Carlton Cross.
Yes, sir.
Mr. Feaster's case. Sir, can you state your name, please?
Yes, sir. Cross and Deion Cross.
Thank you.
What is Judge Portia Feaster, Assistant Public Defender?
Thank you for joining us.
Apologies.
What are we doing on this?
Thank you, Judge. I've been trying to work with the prosecutor to receive an offer on this case. I believe it's the first PCC. We have not yet received that offer. I will request a brief adjournment to see if there is an offer we can possibly get to resolve this.
That objection, August 28, 2025.
Thank you, Judge.
Continue. Thank you, Mr. Cross.
And sir, Judge
I'll come
Simpson.
down and talk to you, Mr. Cross.
Okay, and Judge Simpson, and I've already, on my other case, I've already been, released the treatment, and I'm just waiting for Miss Sarah at correctional service to come down and talk to me.
Okay, I'm sure that'll happen. Okay, and if there isn't an order on this case, they can prepare an order and I'll sign off so that this case doesn't hold you up, okay?
All right, thank you so much, sir.
Thank you.
Have a good day.
You do the same. Court calls the case, People versus DeLorean Hall. So.
Joseph, another people, Your Honor?
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Duhall. Mr. Duhall, could you please state your name for the court?
DeLorean Duro.
Sorry, apologize. Your Honor, two things. First, I had spoken with Mr. Duro about setting this for exam, but in reviewing the discovery after we spoke, I realized that there's some more discovery that I would need before setting it for exam, so it's not there quite yet. I still have to fill out a green sheet for Your Honor, but I'm asking for a short adjournment to do that, please.
August 28th, 2025, 9 a.m. I'll need a green sheet. Bond will continue.
Judge, I was hoping to address bond for Mr. Durrell. Your Honor, Mr. Durrell suggests that he has a number of community supports and stability in the community that would allow him to be monitored safely. He does live with his father in Southgate. His father is a business owner and he works for him. He is being groomed to take over a management position there, and he's made a lot of strides there. He also works full-time at McDonald's, 10 to 6 weekdays, Your Honor, and he has a 4-month-old baby at home. He is asking the court's consideration for bond review.
Response. I'm sorry, I did not hear any of that last part.
I believe, Your Honor, the bond has set is appropriate to the need of the charges that I'm facing.
If the judge literally didn't hear the key argument and the prosecutor isn't even responding in the moment, the defense loses momentum. Courtroom lesson: clarity and timing matter. If your strongest points don't land cleanly, the ruling usually doesn't move.
But given the fact that this defendant is charged with armed robbery, I think the bond is appropriate and set. People for the court's to make further determination.
At this point, what I'm going to do is I'm going to deny the motion to modify the bond in this case. The bond will continue. However, Mr. Bernstein, if you'd like to file a written response so I can get more information, since I didn't get any for the people, I'll be more than happy to consider it.
We'll do that, Your Honor. Thank you.
Court calls case People versus Alexander Sanchez Garcia.
Good morning, Your Honor. Nicholas Monterez on behalf of Mr. Alexander Sanchez Garcia, present to my right. Mr. Sanchez Garcia, can you state your full name for the record?
Alexander Sanchez Garcia.
Thank you. You're requesting an adjournment.
I am, Your Honor, and I spoke with the people before stepping up to the lectern here. If the court would like more information, because the green sheet is a bit vague, then I'm happy to give it, but the people and I, we're asking for 3 to 4 weeks, Your Honor.
That objection, probable cause will be adjourned September 11th, 2025, 9 a.m.
Thank you, Your Honor.
Bound. Thank
you, Your Honor.
Court does call the cases of the People versus Todd Reberg.
Andrew Childress, people. Carl Burdell appearing on behalf of Mr. Reberg in the case ending in 5649.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Reberg in all his other matters. Mr. Reberg, could you state your name for the court?
Todd Reberg. Thank you.
And Your Honor, I would ask you to approach on these matters.
Come on.
Thank you.
Judge.
All right, record should reflect you had a bench conference in this case. You're seeking an adjournment.
Yes, Your Honor.
Yes, Judge.
Because he's still awaiting potential release to treatment.
Yes, Your Honor.
What, the 4th or the 11th, Ms. Young?
Yeah, either works for me, Judge.
Either, Your Honor.
Did I ask for Dell? Did I say Ms. Young?
Oh.
Dell thought I cared. No.
Probably the 11th, Your Honor. Thank you.
She's still doing great.
I am.
Probable cause in this matter will be adjourned to September 11th, 2025, 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor. Keep your head up top. Thank you.
Court does call the case of the People versus Nolan Hearns.
Good morning, Your Honor. James Feifelsky appearing with and on behalf of Mr. Hearns. Can you state your name, please, sir?
Nolan. Oh, he just says.
Yeah. Your Honor, I'm asking for a brief 1-week adjournment for the video discovery, which I believe is forthcoming, and set this for PCC out at the next available date.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor. August 20th.
Okay. The court calls the cases of the People versus Debbie Ann Langford.
And then we have people, Your Honor.
Sherilyn Foster Tucker on behalf of Davion Langford.
Davion Langford.
Thank you.
Your Honor, I am just jumping in on this case. I'm just requesting a brief adjournment to get discovery and review it with my client.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Test for Michael, Test for Miriam.
Joseph Engelman, people, Your Honor.
Good morning again, Your Honor. James Feifelsky appearing on behalf of Mr. Tess Maramian, who is approaching. Come on up, sir. Please state your judge.
التسامح كيف تسامح؟
Sorry.
My name is Tasam Kiel Tasamara.
Your Honor, we are simply asking the court to set this for preliminary examination. I believe I have all of the discovery, and then I can address the community corrections issue.
Why don't we address the community corrections violation now?
Yes, Your Honor. There is a slight language barrier with my client. He does have a green card, but he's from the country of Eritrea, I believe it is. He tells me that he didn't receive any paperwork when he was released from custody, so he didn't know exactly what to do. When I got the notice of the violation from community corrections, I advised him to go over there. He said he did go over there twice yesterday, asking to be enrolled in the intake process. He said that they told him they didn't have any paperwork for him to do that. So he's happy to do that right now.
That's not true.
I don't think there'll be any problems.
That's not true. There's
Okay.
paperwork over there. I can see the paperwork over there. And if they didn't have paperwork, they wouldn't have sent the bond violation. He's not telling you the truth.
I did.
Community corrections is basically supervised release with strict rules. When the judge believes someone is lying or not complying, bond can vanish instantly. Drop in the comments. Was this fair, or did the court move too fast without a deeper look?
Well, I apologize, Your Honor, on his behalf. He tells me there shouldn't be any issues if the court wouldn't mind passing hit for him to do.
When did he say he went over there? Because I'll call right now.
Yesterday afternoon?
Yeah.
They wouldn't have. It's not true.
I did.
I can tell, because I've got the bond violation here from me.
Okay. This is his first experience on this level with the legal system. So I would ask.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded. Are they ready? Court does call the case, People versus Carlos Sell.
Carl appearing on Mr. Self, who's approaching the podium as we speak. Carl, once you get up here, please introduce yourself to his honor.
Carlos Sell.
Thank you, Your Honor. I had previously represented Mr. Self in the matter ending in 5140. Late yesterday, I was just appointed to his other matter, 5186. We are asking that both matters be adjourned in order for me to review discovery and work on a global resolution with the people.
Probable cause conference in these cases will be adjourned August 28th, 2025, 9 a.m. Bond continue.
Thank you, Judge. Defense may be heard as to bond.
Go ahead.
So, Your Honor, Mr. Self had previously received a bench warrant in the case ending in 5140. That's because he was in the hospital with extremely high blood pressure. He tried to leave. He tried to get his doctors to let him go, but the doctors said, well, you can stay here or you can go to court and have a stroke due to his extremely high blood pressure. So he opted to protect his health and stay. So unfortunately, he was predisposed. He did have his intake paperwork. I asked him to provide it for me, but unfortunately that was lost when your apartment flooded, was it?
Yeah.
So his apartment flooded and destroyed a lot of his belongings. So unfortunately, we don't have documentation for the court. He is also interested in.
Was that explained to cocaine use during July?
I don't believe that would be related, Judge, to that particular issue. But we have reached out to Sarah Stewart in the jail about getting into Dawn Farm in-jail treatment program. Mr. Self is a business owner. He owns a barbershop. He's eager to get back to work. He has 3 employees who rely on him for their livelihood, in addition to his own livelihood at the shop. The shop is currently closed and idled while he is in custody. So we are asking that he be released to be able to return to being a productive member of community and a job provider for the local community. And so we are asking for a PR bond on these matters.
I don't need a response from the people. His bond will continue as previous, as I've said it. In this case, motion for bond reduction is denied.
Understood. Thank you, Judge.
Court does call the case of People versus Vincent Lambert.
Morning, Your Honor. Public Defender Lemmy Saab on behalf of Mr. Lambert.
Mr. Lambert, can you state your name, please?
Vincent Lambert.
Thank you, sir. What are we doing?
I'm requesting an adjournment. Your Honor, we are missing some video. I did re-request it yesterday, and as of this morning, Mr. Childers did advise me that it should be released. So we just have to extract it and watch it.
Give you my next available date, August 28th, 2025, 9 a.m.
Thank you, Your Honor.
What was your name,
Thank
ma'am,
you.
so I can call you and ask you a question?
He's talking to you.
It's Miss Saab. Like the car, Saab.
Miss Saab, thank you very much.
Not Audi. Trying to make that clear. Court calls the case, People versus William Bastable.
Joseph, people, Your Honor.
Mr. Denua?
Hi, be next door.
Really? Didn't do me any good.
Hello. I've been. How are you?
Oh, do you know what you're doing on your case today? Did you adjourn or you said?
What's he saying? He might adjourn on video.
Video, okay. Very good.
Sorry, Your Honor. Assistant Public Defender Ben Denowith on behalf of Mr. Bastable. Your Honor, the defense is asking to adjourn a week. We've not received the video discovery. My emails of Friday and Monday were not returned. We cannot conduct the preliminary exam without the video that is referenced in the police report. So we'd ask to adjourn for a week. I do have the form in my bag.
Well, I'll need the form.
Okay.
Without objection, probable cause conference, August 28th, 2025. 9 a.m. Bond will continue. Court does call the case, People versus Tanya Hall.
Good morning, Your Honor. Roger Gill on behalf of Ms. Hall. Tanya Stephanie.
Tanya Hall.
Judge, I've just been speaking with the prosecutor in this matter. I believe we're going to work out an agreement where she's going to be allowed to plead to a misdemeanor. My understanding, we don't have a plea form today, so we're asking for a very short adjournment so we can do that.
Has she been counsel approached?
I believe we have a plea worked out. We need to do the paperwork. We're asking if we could set this matter to the 28th.
All right. I will adjourn this matter out August 28, 2025, 9 a.m. Bond continued. Okay, Ms. Hall, we'll see.
Yes, sir.
You can back on the 28th.
Yeah.
That's you. Okay.
Court does call the case people versus Brian Gerard.
Assistant Public Defender, let me stop on behalf of Mr. Gerard. Your Honor, we are asking to set this for preliminary exam, and to my knowledge, discovery is complete.
Sir, your name?
Brian Gerard.
People have their witnesses available the second. Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Thank you.
Court calls the case of the people versus Ronald Lucky.
Joseph Engelman, people, Your Honor.
Judge, in this matter, we'd like to set this matter for a preliminary exam.
Your name, sir?
I'm Ronald James Lucky.
Discovery is complete, Mr. Kidwell.
Yes, Your Honor.
People have their witnesses available the second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Judge, may I address an issue? Mr. Lucky was staying where the incident, the allegations against him. He was renting a space at 1074 East Forest. He's not allowed to go there. All his worldly possessions are there. He has tried numerous civil standbys. He said he even got a court order that he could get his belongings. Can you be of any assistance, him getting his property from there?
I'm not moving anything, if that's what you're asking.
Pardon me? No, I'm not asking you to help move them. No, not, you know, that.
Judge Otis.
Well,
Ordered it in writing.
who ordered it?
The one that let me out on bond, I believe Judge Otis, they wrote it down on a post, you know.
It's a Otatella.
I'm
It's a
sorry.
magistrate.
I'm sorry. I didn't have my
I'm
glasses.
gonna tell him you called him Otis, though.
Sorry.
Funny.
Right.
Right.
Like the elevator. You have an order that allows civil standby.
He said he was issuing a written order for me to have access to my property. That's what he said on Zoom when I got bonded out.
Has he issued it?
He said he did. I was in custody. I didn't have a pen, a paper, a case number. I have nothing.
Would that be reflective in the file, Your Honor?
I don't see an order. Mr. Killowall, if you prepare an order permitting civil standby to that address to retrieve his property, I'll sign off on it. I don't know.
Okay.
Sure.
All right.
Nothing.
Huh?
Sheriff's done nothing. I've been there more than 10 times with the owner. There's witnesses.
We'll have a court order.
Thank you.
If he gets a court order, I'll sign off, sir. It'll have to be done today, otherwise I'm out for about a week, so.
I'll have it done this afternoon.
All right.
Thank you.
All right, thank you, Your Honor. Do we set the, oh yeah, we did say.
Also, the court
Wait a minute,
keeps me
hold on.
on that address.
Okay, we're gonna take care of it.
September 2nd.
Yeah. September 2nd.
Court calls case, people versus Nathan Gabachi. Tell Otis he needs to do an order.
Andrew Childers, friend on behalf of the people.
Good morning, Your Honor. Alex Warren Green on behalf of Mr. Gabachi. Could you please state your name, sir?
Nathan Gubachi.
Thank you.
Your Honor, at this time, we are asking the court to set the matter for preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available the second.
That's fine, Your Honor.
Preliminary examination in person, September 2nd, 2025, 9 a.m. before Judge Fresh Hour. Bonds will continue.
Your Honor.
Court calls case People versus Ashley Nader.
People, Your Honor. That's Mr.
Yeah.
Morning, Your Honor. Rob J. Kill on behalf of. Judge, in this matter, we're asking.
Your name, ma'am.
Ashley Nader.
Thank you.
Nader, I'm sorry, Judge.
No, it's okay.
Judge. Sure.
That was to you or me?
I was just.
You were answering for me, Kilowog?
Judge, I'm not sure where I am this morning.
Okay. All right. Well, that leads to confidence for your clients. Come on.
He wants you to go take ETG, see if you got any alcohol in your system.
All right. In essence, you're seeking an adjournment of these.
No, we're setting preliminary exam.
Exam. All right.
Hold on, just relax.
People would have their witnesses available tonight.
Tonight?
Preliminary examination in this matter will be set in person September 9th.
Judge, I'm sorry to interrupt you, but I have probate matters, 3 evidentiary hearings starting at 9 o'clock. I don't know how long they're going to go in probate court. It's over money issues. I think they're going to be long hearings. Could we go out? Is it possible?
Doing the 9th.
Yeah, I'd like to tell you I can't do the 9th. You're going to be going when?
To the 8th, third.
30th.
30th of August is fine.
No.
Of September?
Yes, sir.
I'm sure that's fine.
September 30th, 2025. That's at 12 noon. That is before me.
You're going to go test. You're going to take that.
What I'm going to do is I'm going to order that the defendant go over today. Ma'am, if I give you an ETG, there's some postings that indicate that you're consuming alcohol.
I'm not.
Probably shouldn't post in the fashion those are posted. You need to go over and take an ETG test. I'm also going to order that the defendant is to be placed on a sober link unit pending further order of the court. Her bond will continue. However, with those in place, I will then allow the defendant to travel to Kansas City September 3rd through the 8th.
Yeah, Judge, the tether will be removed and sober link in place.
What gave you that impression?
Nothing really. I was asking.
Okay. Oh, that was a question?
I was asking.
That'd be a no.
The tether stays?
Tether stays.
Okay. Thank you for your consideration.
Yeah, I understand the disappointment, but she also left the state without permission, seeming not to understand that order, do not leave the state of Michigan. And I did not throw her in solely because of that. So she's lucky to be out and lucky that her only consequence of that has been a tether. Anything else?
No, Your Honor. Was she supposed to report back today after the testing?
No, she doesn't need to report back today. She needs to go over, take the ETG test. Well, there'll be an order over there and she needs to pick up her sober.
Okay, thank you, Your Honor.
Court calls case People versus Khalil Haddon.
Joseph Bengal, People, Your Honor.
And Assistant Public Defender Lamis Saab on behalf of Mr. Haddon, who is approaching. Mr. Haddon, if you can say your name for the record.
Brian Haddon.
Okay, go ahead.
Your Honor, discovery is complete in this matter, and we would be requesting to set it for preliminary exam.
People have their witnesses available the second. Preliminary examination, September 2nd, 2025, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
That's in person. Bond will continue. Court calls case People versus Dwight Williams.
Andrew Childers appearing on behalf.
I'm here.
You know what? What's going to happen though is I'm going to call your case and you'll be nowhere to be found. Yes. The third 30.
Is this the way? Judge, can we pass the Mr. Williams matter? He had called me saying he was having trouble getting a ride from Detroit, but he promised me he'd try and be here.
Oh, he's not on a bus.
You being a considerate judge you are, I know you'll take that into consideration.
So this is just a delayed bench warrant.
Basically,
Yeah,
yes.
okay.
Thank you.
Pass. Court calls the case People versus Curtis is it Moncanito? Moncanico?
Number of people, Your Honor.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Mechanical. Sir, could you say your full name for the record?
Curtis Mydro Mechanical.
Thank you. And Your Honor, we are requesting just a very brief adjournment. We haven't yet received discovery on this file. Our support staff reached out yesterday to the prosecutor's office, and I believe we should be getting that very soon.
August 28th, 2025, 9 a.m.
Thank you.
Bond continue. Thank you. Court calls the case People versus Derek Lovely.
Joseph and number of people.
Greta Bird on behalf of Derek Love.
I was wondering where you were. It was not going to be a complete day unless you showed up.
I was thinking the same thing about you, you know.
Your name, sir?
Derek Lovely.
Thank you. All right, you're asking for an adjournment?
Please.
4th or the 11th, sir?
The 4th, please.
4th. Probable cause conference will be set September 4th, 2025, 9 a.m. Bond will continue in this case.
You and your honorable court have a great day.
Thank you. Court does call the case of People versus Michael McLean.
And on behalf of the people.
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. McLean, who's approaching. Could you state your name for the court?
Michael McCartney.
Your Honor, in this case, I am respectfully requesting that it be set for preliminary examination. My information is I don't think there's any outstanding discovery.
People have their witnesses available the second.
We'll do our best, Your Honor.
And
Preliminary examination in this matter will be set September 2nd, 2025, 9 a.m. That is before Judge Freshour.
thank you, Your Honor. May I respond briefly? My understanding is this is the only case that is holding my client. He does indicate that he has an alternate place to stay besides with the complaining witness. The date on this complaint is from June 1st. I don't believe there's any allegations of any like bond violations or contact. This was a delayed arrest. So Mr. McLean wasn't arrested at the time of the offense. He was actually in treatment, and then he was completed the first phase of treatment, was out, was not having contact with her, and then was arrested. So I think that shows that he can be out of custody and stay away from her and not have contact with her as he was for at least a few weeks before his arrest.
Your Honor,
Ms. Endo, yes.
I would be objecting to any modification of bond. The facts of this case are that he was released from jail on 5/28/25 and immediately went to her residence after being released. He was formally served on that date. And then on the preceding days afterwards, he was on her property, hiding on her property. When she would come outside, he jumped out and yelled, "Who do you have in your residence?" He then left and then began leaving her voicemails and calling her. A friend also saw him on her property. So I had concerns given that. I also have concerns given that of his criminal history. He has a previous home invasion first conviction from 2007, a 2022 dismissed home invasion first, a 25 dismissed PDHD second, and malicious destruction of a building. And he currently does have a hold on standard for a domestic violence case with bond set at $500. So at this point, I would have concerns for her safety and communities, and I would ask that bond remain as set.
May I respond briefly?
Sure.
He was released from jail, but there was no contact order at the time he went back to her address. So I just want to clarify, it sounded really bad the way
Yes,
the
it did.
HBA.
You were being zended. Go ahead.
He was not aware of and not served the PPO until afterwards. So it wasn't like he went to her residence after being out of jail and being told to stay away from her.
So he got arrested on what?
If I can clarify, I'm not sure exactly it's an arrest date. If I can clarify, he went to the residence on 5/28, was served the PPO that day, and then in the preceding days after he was served the PPO and told he should not be having contact, he went back to her property and then was also calling her. So he was violating that PPO after it had been served and he had been given notice.
Your Honor, he does dispute the timing of that. Obviously, I know this court is this is not a hearing date, so I know we can't get into the details. The missed call log and discovery shows 5/28 and not after. So we dispute that he made any contact with her after being served the PPO, but obviously that's the purpose of the exam. And so I just wanted to note that.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.